Hi friends, in this video we are going to deal with a case summary of the latest Supreme Court judgment pronounced now in the area of property law, especially matters involving that an encroacher cannot be termed as a transferee to seek benefit of Section 51 of the Transfer of Property Act. To know more about it, please watch this video fully. If it is helpful to you, please like, share and comment, and never forget to subscribe to it, and further click on the bell icon next to the subscribe button. In the important judgment titled Baini Prasad, Death Through Legal Representatives versus Durga Devi, pronounced on 2nd Feb 2023, the plaintiff filed suit for possession of land by demolition of structure put up thereon and for injunction restraining defendant from interfering on disputed land. The trial court held that the plaintiff was the owner of the encroached land. On appeal, the first appellate court confirmed the findings on ownership and the question of encroachment, but modified the judgment holding that the plaintiff was not entitled to recovery possession based on principles of acquiescence. On second appeal, the Himachal Pradesh High Court set aside the judgment and decree passed by the first appellate court and restored the judgment and decree passed by the trial court. Being agreed, the present appeals have been filed. The Supreme Court has held that Section 51 of TP Act would reveal that in order to acquire the right to require, one should be a transferee within the meaning of TP Act and for the purpose of said section. In short, Section 51 applies in terms to a transferee who makes improvements in good faith on a property believing himself to be its absolute owner. The defendant failed to establish that he is a transferee within the meaning of TP Act and for the purpose of Section 51. In order to attract the section, the occupant of the land must have held possession under the color of title. His possession must not have been by mere possession of another, but adverse to the title of the true owner, and he must be under the bona fide belief that he secured good title to the property in question and is the owner thereof. In short, Section 51 gives only statutory recognition to the above three things. At the same time, in the present case, the concurrent findings of the courts below are that the plaintiff is the owner of the land in question and the defendants encroached upon it and effected construction. The defendants failed to establish the above mentioned three things. The evidence on record would also show that even the construction was effected in deviation of the approved plan. In the light of the concurrent findings on the questions of ownership and encroachment, it can only be held that it was after encroaching upon the land in question and ignoring the absence of any title that he made structures thereon at his own risk. Once it is so found, the defendant cannot be treated as a transferee within the meaning of TP Act and for the purpose of Section 51. Therefore, the defendants are not entitled to rely on the provision under Section 51 to seek for restoration of modification made by the first appellate court with respect to demolition and possession. The defendants rightly did not take up the plea of adverse possession, and in the circumstances, being not a transferee for the purpose of Section 51, he cannot legally require the plaintiff either to pay the value of improvements and take back the land or to sell out the land to him at the market value of the property, irrespective of the value of the improvements. It is relevant to note that the trial court took note of the factual position that despite raising the specific contention that he affected the construction of his residential house along with veranda in the year 1986, the defendant did not produce the completion certificate of building, including the construction on the land in question, from the local body to establish the asserted fact. When the first appellate court also took note of the issuance of Exhibit PW 18A and also submission of Exhibit PW 12A, it should have taken into account of the following facts which are explicit from the records and duly considered by the trial court. Firstly, it was the burden of the defendant to establish the fact that the plaintiff acquiesced in the infringement of his legal right and still stood by and allowed the construction. In that regard, it should have taken into account the fact that despite asserting that the construction on the land in question was carried out while carrying out the construction of the residential building on his own land in the year 1986, as per the approved plan, he failed to establish the same by producing the completion certificate from the local authority. Secondly, if that contention is taken as true, he could not have taken up the contention of the acquiescence on the plaintiff, as it was also his case that the plaintiff purchased the land in question only in the year 1987. Thirdly, the oral evidence and the documentary evidence on behalf of the plaintiff would reveal the factum of raising objection on carrying out the construction. In the absence of any title over the same, at least a defective title, the defendant could not have claimed bona fides on his action in carrying on the construction. In the said circumstances, the mere delay in instituting the suit, especially when it was filed well within the period of limitation prescribed, should not have been held as amounting to acquiescence. The plaintiff, after sending telegraphing message on 22nd September 1987, approached the Deputy Commissioner and ultimately obtained report revealing encroachment on the part of the defendant on 10th December 1987 and then brought the suit on 11th May 1988. How can it be said in the circumstances that the plaintiff has not immediately taken proceedings against the defendant and therefore she should ever be debarred from asserting her right for recovery of possession of her land from the encroacher, even after establishing her title over the encroached land in a suit instituted well within the prescribed period of limitation? The entire circumstances revealed from the evidence on record unerringly point to the fact that the defendant encroached upon land belonging to plaintiff and without bona fides effected constructions, which is veranda, which is extension of a residential building. Considering all these circumstances, this court does not find any flaw, legal error, perversity, or patent illegality in the findings by the High Court in favor of the plaintiff, and in setting aside the judgment and decree of the First Appellate Court, and also in restoring the judgment and decree of the trial court.